So he does that. Judge put him in jail. So then we find out also next, Brian Steele motions for a mistrial. And we got to get into some legal stuff again real quick because of this mistrial thing. Brian Steele motions for a mistrial. The judge already knows what he's about to say because the motion for a mistrial is on the grounds that the state knowingly put a witness on the stand that was going to plead the fifth. Now, this is my whole thing with this argument, right? The judge said continuously they didn't know or we didn't know he was going to plead the fifth. We heard him say in court like 5 times this morning that he was taking the fifth. His lawyer said like 10 times before that he was taking the fifth. He told them last night he was taking the fifth. So I don't understand when the judge is saying we didn't know he was going to do that. He said it like 10 times himself. So I don't understand that whole thing of like we didn't know he was going to take the fifth. So Brian Steele makes the motion. The judge is like, nah, we're not doing that. But let me just read a little bit though, because I feel like I need us and I need for myself to understand why is it wrong to put somebody on the stand if you know that they're going to take the fifth? And what I was trying to find out is it against the law? Is it like case law? Is it frowned upon? What is it? Like, what's the restriction of it? Why is it such a big no-no? Let me bring up a window for y'all right quick. Boom. All right, we're going to go down a couple paragraphs. All right. Please like the video. Thank y'all. All right, so pretty much a witness's invocation of the privilege against self-incrimination is not an uncommon occurrence in criminal proceedings. Some Fifth Amendment privileges claims come as a surprise. Others may be anticipated but are uncertain until the witness actually takes the stand because the witness has equivocated about asserting the privilege. In these situations, knowledge that the witness will claim a privilege cannot be imputed by the lawyer. The idea is that if we have been arguing this case one way all this time throughout the whole trial, and then we are saying we didn't do XYZ, and y'all are saying you did do XYZ, and this person that we about to come testify was one of the people that did it with you, right? And then that person comes up there on a stand, and the prosecutor knows that they're going to take the fifth. That person comes up on their stand. They're like, hey, did you help Young Thug kill Donovan Thomas? And he says, I plead the fifth. That will automatically make the jury say in their head, that's like a psychological thing. It'll automatically make a viewer and the jury say in their head, oh, if him answering that question incriminates him, that must mean he did that. Now, it's not that that's against the law, but what is considered is like a dirty tactic on the prosecution because they know it's like a psychological tactic against the jury. So let me pull this thing back up and let's read this paragraph here. What they say about it is this is like a professional conduct thing because it's looked at like a trick, almost like a dirty play, pretty much, right? The rules of professional conduct do not directly address the issue. While the rules prohibit conduct prejudicial to the administration of justice and denouncing use of evidence gathering methods that violate third-party rights may be cause for concern, they provide little, if any, insight into the propriety of this technique. See, it's called a technique. Like this is a thing that, you know what I'm saying, it's kind of hazy. It's considered a dirty play. Let's move down to the next section. Specific instruction on this issue is available in the ABA standards relating to the administration of criminal justice. Standard 3.5.7c of the prosecution function advises that prosecutors should not call a witness in the presence of a jury who the prosecutor knows will claim a valid privilege not to testify. Standard 4-7.6c of the corollary defense functions Corollary defense function imposes an identical obligation upon criminal defense counsel. At least one ethics writer claims the violation of these criminal justice standards also constitutes a violation of Rule 4.4, which prohibits using methods of obtaining evidence that violate the rights of a third person. Right. So essentially, like I said, it's considered a dirty play. It's a dirty tactic to trick the jury and also to make everybody look guilty that's involved, right? And the state was told multiple times. I mean, we heard them tell the state that he was going to take the fifth. So why was he still brought up there? And then the judge saying that he didn't know, very crazy to me. So after Attorney Steele motioned for a mistrial, the judge asserted, hey, we didn't know that was going to happen. I don't understand that. He said, we didn't know that was going to happen, so I'm going to deny your motion. I'm thinking Brian Steele needs to take it above his head and file for a motion. I don't see how this trial is going to continue. But there's one, so they started arguing, like the lawyer comes back up there and says, like, so they took Kenneth Copeland in the back, like he's going to jail now, right? So let's look at some of this this argument back and forth between Attorney Love and Attorney Melnick. Pretty much Attorney Love kind of hinted at or said flat out that it's witness tampering going on. He's saying that the lawyer just popped up out of nowhere. Kenneth Copeland said he didn't have a lawyer. This lawyer popped up out of nowhere, and he seems to be working with Brian Steele in the defense because they're in the courtroom doing gestures to each other. They're like, I don't know what's going on. I tried all that. So let's
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal. But I
don't want you to do that, sir.
I can assure you that the decision to invoke the fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel.
My boy said he's reporting her to the state bar for contacting a witness that she knows to be represented by state counsel. It's about to get hot in here.
She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." Mm-hmm. The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you I've known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that if you probably have a conversation with him now, you're probably going to tell him, well, That was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with them, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and call. I'll call him out before the jury comes in
really ain't scared
on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it.
The craziest part about this part we're looking at right here, this is not like, it's about to get even crazier when we look at this Attorney Love versus Brian Steele argument. It's about to get crazier. If you didn't watch the trial today, stay tuned. But let's keep listening.
Once already, I'm going to ask him before the jury gets out here on Monday, is it your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 days.
I want y'all to see something real quick. I want y'all to see something that I noticed as I was watching this trial today. Like I keep saying, and like this state knows, Kenneth Copeland was such an important piece to this case. It's almost like they don't have to continue with this case now. It can be over. It's done. Let the jury deliberate based on what they have now, because this was the one that was going to make these people the boogeyman of the Atlanta streets and the ones who are murdering with impunity. Look at Simone Hilton after. Just look at her after all of this happens. Just watch her mannerisms. She's shaking her head. She is disappointed beyond belief. Look at this, y'all. Do y'all see her? Y'all see my girl right there? Shaking her head. She's tapping her foot. She's shaking. She just can't even believe what's going on right now. Do y'all see that? Let's go back and look again. Look at her. She's shaking her head. She's doing this while the jury is walking back in. This is what happened right after Kenneth Copeland had took the fifth in front of the jury. This is the jury coming back in to be told that they're done for the weekend and they can go home. She is beyond disgusted because the case is over. This was her witness. She was about to slam dunk it. Kenneth Copeland is the person she'd been talking to for the last year and some change about what they're going to do, the strategy, how they was going to use him in the situation. He was down to testify. According to them, he was down to testify until like yesterday. That's what Hilton is saying. Hilton is saying we have been talking and there've been nothing but cordial conversations. There was no problems. We don't know what happened. Somebody got to him. They're kind of saying the lawyer has got to him, and the lawyer must be affiliated with Brian Steele somehow, because the lawyer got to him. The lawyer popped up after 2 years of this case going on. The lawyer just popped up yesterday. And Kenneth Copeland didn't call the lawyer. The lawyer found out he was about to testify and called him. A lot is going. Even the judge had to tell Melnick, hey, I get it. You're a good lawyer. I've been knowing you for a long time, but listen, you do have a duty to your client, but you also have an even greater duty to the tribunal, which he was talking about himself, to the judge, to the courtroom and to the judge. Even greater responsibility to the judge and the law. Do not let this case get you jammed up because you want to break a rule to try to help somebody out, or you want to break a rule to try to help your friend out, or you done took a bunch of money to do something you know you shouldn't be doing. The judge kind of said that a little bit, like, listen, you got a bigger duty to me. Don't play yourself around here doing stuff that you know you shouldn't be doing, unethical stuff that really can get you put in prison. You know what I'm saying? And I said it earlier, like this the way this case is going, one of these lawyers is not going to be a lawyer after it's over. Somebody's getting their license taken. Like I'm just predicting that because the allegations being lodged across the aisle are, pretty bad in the court. Especially, prosecutors have high standards. They're supposed to have high standards. We know that they do dirty stuff all the time. But the disappointment on Attorney Hilton's face, and I feel kind of bad for her. You know why? Because she was the one that was, and she was doing some bull crap sometimes, but for the most part, she was the best lawyer on the state side. She was trying to do it by the book. She was sharp. She was on point. She turned over evidence when she was supposed to, and the defense has shouted her out for that many times, saying Hilton is doing what we need her to do. It's Love that's not doing what we want, what she's supposed to do. Hilton is on point. Love is not on point. So even the defense have given Hilton love for the way she's been handling this stuff, and you could see her in the court, like you just seen how disappointed she was. You see what I'm saying? I feel like they're defeated. It's a wrap now. Kenneth Copeland got one question asked to him in front of the jury, how old are you? And their case is dead. I plead the fifth about his age. They could have never predicted that. Let's look how evil. So remember we talked about OCGA 24-5-507 that says that you can be granted immunity and it forces you to testify and you really don't have your Fifth Amendment right. It withdraws it. There's another section in there that we didn't read. And let's look at the clip first, though. This clip is insidious to me. This is evil that states even write laws like this. Look at them.
Like of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial. Because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick has, I'm certain, is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 24-5-507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Do y'all hear that? According to this statute, this man can be held until this trial is over. And Attorney Love didn't say he just can be held. She says she believes it is the duty of the court to make sure he is held in the Fulton County jail until his trial is over, because that's how important his testimony is to this trial. He should be punished for trying to uphold his constitutional right to the Fifth Amendment. He should be punished so much that a trial that many people have said is going to last 2 years long with 400 witnesses, this man should be held until it's over, because he won't come in here and snitch the way we want him to snitch. Ain't that something? Let's read this piece here. Oh, that's not what we're looking at. Let's read this. If a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. If the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. essentially, what this is saying is there's no, if you violate, because like if you get held in contempt of the court, like normal contempt, like you just had an outburst and they held you in contempt, you can go to jail for like up to 20 days. But if you get held in contempt under this order, 24-5-505, it does not expire. You can be held until they don't need you anymore. Or until what they say is you purge yourself of contempt by testifying. Meaning the only way out of this is to testify. So they could drag this on as long as they want, which the case is already long anyway. So according to this statute, it has separate punishment guidelines where it's almost like we don't have to punish you. This is like a way to get around due process. So you don't get a Fifth Amendment right and you don't get a trial. They get to hold you as long as they need to hold you. You don't get the trial. You don't get to defend yourself. The only way to get out of it is to testify truthfully and not evoke your Fifth Amendment right. That's evil to me. I'm trying to figure out, why is that even a rule? Why is that who wrote that? This says Code 1981, enacted by Georgia in 2011, page 99, like House Bill 24. Do y'all hear that? This man, there's no way. Thanks for the super chat, Chili Panda, or is that Chili Panda or Chill Panda? I heard the jury rolls their eyes when love speaks. I believe it, because Attorney Love is up there rubbing everybody the wrong way, man. She really is. So that, to me, that is a very like sick thing to put as law. Like, yo, you can be held until the trial is over, and you don't get a trial to fight for yourself. There's no bond type of thing. There's nothing you could do. You just have to be held in whatever county you're in the county jail, until you purge yourself of contempt by testifying, or until the trial is over, pretty much, since we don't need you anymore. Even if the grand jury is dissolved, you don't get to get out. You still need to sit until you have purged yourself of contempt. Very, very, very sick stuff right here. Very sick stuff, how they have ways to get around the Constitution with things like this. Normally, you lose your Fifth Amendment right if you took a plea deal. Like Trontavia Stevens couldn't invoke his Fifth Amendment right. He waived it, though. He willfully waived his right to invoke his Fifth Amendment, right? This guy, Kenneth Copeland, didn't do that. He didn't take a deal. He was never a defendant on this case. The reason that he wasn't a defendant on this case is because they had been banking on him helping them out. If he was a defendant and they had him sitting in jail for 2 years, he really wouldn't have helped him. But now he's been free this whole time, and he pretty much he played them. Look, he played them so bad, right? They said, do y'all have anybody else that could come testify Monday in case he does this again? They said, no, we had him pretty much locked in for like a week. They don't even have nobody else lined up to testify until 2 weeks from now, because this whole thing was about this man. Y'all see what? Just the fact that they just didn't even have nobody else they could call right then is crazy. So if he evoke his Fifth Amendment right on Monday, they probably gonna go home again. You know what I'm saying? We never know. Shout out to Uncle Paulie for the super chat. Love the show, my brother. Info without the fluff. Shout out. What's going on, Paris? Did Woody sign the immunity paper or not? This is the thing about this. This is what we learn in Paris. This is not this immunity order that they used is not a deal. It's not a deal for him. The immunity order they use is a forced testimony order type of thing. It's like, we're forcing you to testify against your will. You don't get a Fifth Amendment right. We're forcing you. You don't have to agree to it. Your lawyer nobody has to agree. Only people that need to agree is the district attorney and the judge in the case. This is not a deal for Woody. This is not a deal for Kenneth Copeland. That's why he's being punished right now. This is not a deal. This is not a positive thing if you get this type of immunity. It's like they're forcing you to take this thing, and they're forcing you to waive your own rights, but then they're waiving it for you. Right? He found out about it this morning because Hilton, after the email went to Hilton and Brian Steele that, hey, my client is invoking his Fifth Amendment right, Hilton got on it right then, drafted up this order of immunity, sent it to the judge, And this morning the judge signed it. And then that's when everybody else found out about it. So like this is like a unilateral forcing or waiving of rights or withdrawing of rights or just like stripping a person of their rights. Is really